to 9 a.m. Bond continued with its conditions. Thank you. Court calls case of the people versus David. Is it Machasik? Machasik?
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Machasik. And sir, can you unmute and state your name for the record, please?
He took it off, stupid.
Okay, look, I don't know who you are, Life 3, but you're about to be kicked out of the courtroom. Mr. Machasik, can you figure that out? If you can't figure it out, there should be a clerk right near you somewhere. You can ask them for help to unmute.
I apologize, Judge Simpson.
Who are you?
Nathan Mason.
Got her. Okay, I don't want to ever hear that in my courtroom about anybody.
I apologize.
I don't know if that's going to be good enough, but I'll get to you when you get to your case. Mute yourself.
Yes, Your Honor. This is John David.
Court calls the case of the people versus Nathan Mason. That's the one.
Good afternoon, Your Honor. Allie Zenda on behalf of the people.
Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Miss Mason. Miss Mason, please unmute and state your name for the record. Miss Mason, please unmute and state your name for the record.
Had a whole lot to say before.
Miss Mason, we're ready for court now. Would you please unmute and state your name for the record?
I already got in trouble because I thought I was muted and I wasn't. And this guy, he was calling this guy name. He was sitting there looking crazy. So I was like, he's looking off.
Miss Mason, we got
but I didn't know harm.
Miss Mason, will you state your name? State your name for the record, please.
Nathan Mason.
Thank you, Judge. Today is the date and time set for pretrial in this matter. I've spoken to Miss Mason and to the prosecutor's office.
How'd that go? No, go ahead.
It's been rough, Judge. At this time, there are no offers on this file. If we could adjourn this matter, Your Honor, so we can hopefully get an offer, and if not, move it forward in another way to resolve it, Judge.
But could I talk to Judge? May I say something?
No. What do you not?
I was ordered to pay $180, but I don't have an income because I'm disabled now. So I was trying to explain to him that I talked to a court clerk at 14A District Court. I called the bus back up there and talked to her and told her my situation.
Mason?
She said I could make a payment plan, but they never sent me through the mail.
Miss Mason, is that this
yes?
file? Because if that's not this case,
excuse me,
is that on this file? Because if it's not on this case, Judge Simpson cannot do anything about that today.
Well, which case is it? It got to be the one I went to. It got to be the one that I already got ruled on because is it a case from that I had a bench warrant on? It was a warrant out for me on this case because I didn't pay the $180.
Okay, you never had a bench warrant on this one.
Me?
You never had a bench warrant on this one.
Is this the one where I had the crack pipe, the paraphernalia, and I got caught stealing from Myers?
No, this is the one where you were stealing from the store. Allegedly.
Right, from Myers, right?
Yep.
From Myers or Home Depot. Okay, that's what I thought.
Yeah.
And that's the one that you ruled on for.
No, this is Myers. This is Meyer.
That's what I know.
You were stealing stuff.
That's the one that
allegedly. This has nothing to do with the crack pipe. That might have happened before or after. It has nothing to do with that.
It happened at the same time, Judge Simpson. It happened
Well,
at the
I
same
don't know
time.
that.
You gave me 180-day rule. You gave me
Miss Mason,
$80.
Miss Mason, anything you say can be used against you.
What?
So would
What?
would you please stop until we can try to get this matter resolved? And we can deal with all that stuff at a different time?
Okay, so what's, I don't want to go to no trial. What's gonna take place now?
Okay, I was just going to adjourn it out so that everybody could talk to each other about it and get it. So I'm adjourning it to July 6th.
Thank you, Judge Simpson. Thank you, sir.
Thank you, Defendant Mason. All right, you have a great day.
Thank you, Judge.
Thank you, Your Honor.
You have-
There it was. Whole day just flying right along. And it happened. Okay. I'm afraid to call anymore. I just this is all Feaster.
So what happened, Judge?
Miss Kleeman, are you there?
I am.
Miss Kleeman, we don't have days like this.
I know.
I don't know what happened.
I don't know what's going on today.
Feaster,
Sorry.
no, it had to be you. This doesn't happen to Kleeman. All of what happened in the last 20 minutes would not have occurred.
Are you sure you want me to come back on July 13th?
I'll have to make a decision after some deliberation later because I don't know.
I don't know.
All right, let's try this one.
Jessica Blanche, appearing on behalf of people.
And good morning, Your Honor. Christina Costantino, appearing with and on behalf of Ms. Sierra Robinson. Ms. Robinson, can you unmute and state your name for the record?
Sierra Robinson.
All right, what are we doing?
Your Honor, this is a date and time set for probable cause conference. At this time, we are requesting that this matter be scheduled for an in-person preliminary exam at the soonest available date, and I would like to address my client's bond.
Preliminary examination in this matter will be set for May 2nd, 2023, 9 a.m., and that is before Judge Perry.
Thank you, Judge. Might I address my client's bond?
You may.
Your Honor, my client's bond is currently set at $2 million with no 10% provision. We are asking for a reduction of that bond. My client's 25 years old. It's my understanding she does not have any criminal history of any kind. She's not presently on probation or parole or anything of that sort. She is pregnant currently. And it's my understanding that she's been having some health issues while in the Washtenaw County Jail related to her pregnancy. We have some concerns that she may not be able to get the appropriate treatment for both her health and her unborn child's health. She does have employment lined up. Should she be released, she would have employment lined up at Kroger. She would be residing in Ypsilanti with her mother. I personally spoken with her mother and confirmed that. Her mother is on dialysis, and Ms. Robinson typically helps take care of her mother tremendously. So she has some family obligations that a lower bond could help her to accommodate as well. She does have a high school diploma, and she does intend to enroll in college sometime in the near future should she be released. It's my understanding, Your Honor, that this warrant was authorized sometime in February. At the time, my client's address was not the same address that was on file with the felony complaint. My clients indicated she never received notice that there was any sort of warrant. And she did come in custody. That was the first time that she learned about the warrant. It's also my understanding there'd be no issue with any sort of no contact order. My client does not have any need to see the complainant in this case. So we would ask the court to consider a bond reduction from the $2 million bond. My client doesn't have any financial means to post even close to a $2 million bond. But we would ask the court to consider a $10,000 bond. And I know that's a significant reduction.
All right, I'll hear from the people, but my understanding is factually, Ms. Robinson's accused of stabbing an individual who was pregnant, and then that individual had to be induced into labor. That's a, go ahead.
Those are the allegations, Judge. This was a random stabbing at a bus stop. So I have huge concerns for the community. While I sympathize with the fact that the defendant is pregnant herself, she did stab the victim multiple times, and in fact said that when the victim said, "I'm pregnant," she said, "I don't give a fuck. That's why I stabbed your bitch ass." And she was induced and almost bled out on the street. So I would not be okay with any reduction in bond in this case, Your Honor. I believe she's a threat to the community.
And Judge, if I might respond.
Yes.
Your Honor, first and foremost, we dispute those allegations, of course. I'd also indicate the discovery reveals that the complainant did not ever see a knife or any other device which was used to allegedly stab her. And for what it's worth, my client was also injured as a result of this and suffered a miscarriage shortly after the encounter with the complainant. But we dispute that there was ever any sort of stabbing, which is supported by the complainant's own statements to police that she did not ever see any sort of weapon that my client allegedly had.
She didn't see it, or the person that stabbed her didn't have it? I mean, there are differences.
It's my understanding from the discovery that the complainant said she believed she was stabbed, but never saw any weapon, could not describe the mechanism by which she was stabbed.
Okay, that's what I thought. Okay, motion for bond reduction denied. Bond will continue as set.